Alrighty, and I think we're live. Good afternoon, all, and welcome to another Insolvency Bites chat with me, Alice Rue from SMB Advisory, and the wonderful Stacy Miller of Cronin Miller Litigation Lawyers. Hi, Stace.
Hi, everybody. Hey, Alice.
Hello. I would like to begin today by acknowledging the traditional owners of the land upon which I live and work, the Yagara and Turrbal people, and pay my respects to elders past and present, and extend that respect to all Aboriginal and Torres Strait Islander people on the call today. Thank you, everyone, for joining us today in LinkedIn Live Land. We're also recording this, and it will be available shortly after we finish recording on the Insolvency Bites YouTube channel. Today, we're going to have a chat about the case of the Commissioner of Taxation and Bosanac. Now, this is a case that takes a really good look at the concepts of resulting trusts and also the presumption of advancement. It's not actually an insolvency case per se. There's no bankruptcy or bankruptcy trustees involved, but it does look at the issues of resulting trusts and the presumption of advancement, which are concepts which are often dealt with in insolvency situations. Stace is going to lead us through the case today, but before I hand over, I just want to remind everyone you can put any comments or queries that you might have in the chat, and if we can, we'll try and discuss them through the course of our discussion today. Otherwise, we're happy to take them on advisement and come back in due course. Alrighty, without any further ado, Stacey, tell us about the Bosanac case.
Let's get into it. All right, so look, this one's had a bit of a history to this point, so let's just step that out quickly before we get started. Initially, there were recovery proceedings commenced by the Commissioner. Is that me buzzing, Alice?
That was me that time.
That was you? Okay. Sorry, all the sound effects. Commenced by the Commissioner against Mr. Bosanac back in 2016. And the Commissioner actually obtained summary judgment against Bosanac for an amount in excess of $9 million. So no small amount, plus some costs. Bosanac sought a stay on the execution of that judgment and achieved that stay for approximately 3 years before it was lifted. And then in December 2019, the Commissioner of Taxation commenced proceedings seeking a declaration that the wife, Mrs. Bosanac, held 50% of the matrimonial property she shared with, or she resided in with Mr. Bosanac, on trust for the husband. So we'll get into the facts and issues around all that in a minute. And I do want to just briefly explain those presumptions that you mentioned as well, Alice, because obviously we need to understand those before we get into it. But it was back in 2019 that these proceedings were commenced, and we get that first instance decision, that decision of the primary judge, which actually applied the presumption of advancement, left the Commissioner of Taxation unsuccessful, and Mrs. Bosanac had that her property felt like she had successfully defended that claim, and all was good with the world. But of course, the Commissioner filed a notice of appeal to the full court of the Federal Court of Australia, and that appeal was held and heard by the full court constituted by 3 judges, and a decision delivered on the 31st of August 2021, which had a finding that the presumption of advancement was rebutted. So following that, another appeal. This time there was a special leave application to the High Court, which was granted, and Mrs. Bosanac, who's the current appellant, has filed that application. It was granted in April of this year, and is now partway through. You can actually follow the case, for those law nerds out there, via the High Court website. Of course, certain documents are publicly available. I've read, for example, the written submissions of the appellant, which were filed at the end of May. The written submissions in response of the Commissioner are due in just 7 days, on the 28th of June. So you can, of course, follow that live action decision for those who are interested.
We can always come back for an update after you've read that.
Oh, absolutely. All right. So that's just the history of the proceeding. We'll get into the facts of the case in a moment. But you can see how it's taken a long time even just to get here. But let's explain some of the relevant legal doctrines or presumptions that we're going to keep talking about. The first is a resulting trust. So a presumed resulting trust will arise from the legal assumption that a gift was not intended where the legal title does not reflect a party's contributions to a purchase. So where there's purchase money contributed by a number of different purchases, for example, in equal or unequal shares, and the property is purchased in joint names, there is, generally speaking, a presumption that the purchasers hold the legal estate in trust for themselves as tenants in common in shares that are proportionate to each of those contributions. Alternatively, if there were 2 or 3 contributing but only one recorded on the legal title, there's a presumption of that resulting trust that one person who might be recorded on legal title is holding the shares in those proportions contributed by the others pursuant to a resulting trust. Does that make sense? Clear as mud?
Yeah, that makes sense. So I think for mine, it's all about in my, legalistic language, but it's all about the vibe. It's if you put in, should you have the entitlement to get the benefit of it, or should you not, because you really didn't do much to get it at the end of the day.
Yeah, but where there's been a financial or monetary contribution, and there's no other presumption rebutting that, or nothing else rebutting that resulting trust, then usually you would argue. And that this comes up a lot, obviously, in insolvency cases, Alice.
We look at it a lot, and we look at it from so many different angles of contribution to see sort of who's put the money in, but also who's provided for upkeep and maintenance, and who has contributed in different ways, and whether or not that should alter what is seen as the legal sort of distribution of that property between the parties.
Yeah, absolutely. So let's move on to the presumption of advancement, which is the key one here. A presumption of advancement will rebut the resulting trust presumption in some cases. But what it means is that it is presumed that certain payments were actually a gift. And that certain relationships will give rise to a presumption of an advancement. And that presumption that, that payment or that transfer was in fact a gift. Now, the relevant relationships are husband and wife, but the transfer is from the husband to the wife, which is presumed to have been made by way of advancement. Very important clarification, it does not apply to a transfer from a wife to a husband. That's a somewhat antiquated notion, certainly a little bit out of step with current societal expectations, but it's what it is. A parent to child is the other relevant relationship.
So just in terms of that husband to wife thing, it's not as though it's been dormant for a long time either, because we dealt with this. I think you're going to talk about Cummins in a minute, but I mean, the first time I sort of really it hammered home was when we first started, reading Cummins, and we learned about Cummins, and it was all about the husband transferring or purchasing, for the wife, and not, you couldn't have it the other way. So, that was quite some time ago now, and the law has had a little bit of a while to catch up with that, given, as you said, and I agree, the antiquated nature of that relationship. Yet it still prevails, doesn't it, that it's only the husband to the wife?
Yeah, absolutely. It's still good law. So Cummins was back in 2006, but it's still good law. And the primary judge, you'll see on this decision talks about precisely that. I don't think she uses the word antiquated, but that perhaps it's out of step with current expectations of society. But until such time as the High Court changes that law, or there's some legislative change, then it is what it is, and it's still being applied. So yes, it's an interesting one. So before moving into the case, then there's some key things to remember about that presumption. So It can be rebutted either partially or completely by evidence that at the time of the transfer, no gift was intended. But the burden of rebutting that and evidencing that no gift was intended lies upon the person asserting that. So in these cases, it's going to be the commissioner, as you'll see. And I know that we've pointed out this isn't an insolvency case, but this presumption of advancement is not able to be relied upon as a defence or an argument if there's evidence that there was an intention to defeat creditors. So that intention will overpower the presumption of advancement. Of course, this case is between the Commissioner of Taxation and an individual. It's not an insolvency case. There's no trustee and bankruptcy involved, but really relevant principles that, as we've already said, come up a lot in the cases we deal with, Alice.
Yeah, absolutely. One thing that I just really liked, and it was on the first page, I've got it highlighted here, of the decision, where it actually talks about the difference between a presumption and an inference. And I thought that was a really handy distinction to make. And it says here that the presumption or a presumption differs from an inference in that an inference is something which may be drawn from facts directly proved, whereas a presumption, unless it's rebutted, and that's what we're talking about, rebuttable presumptions today, but a presumption, unless rebutted, operates automatically once a certain fact is proved. So you've proved one thing, and then the presumption comes in, whereas an inference is something that you might draw. And when we were talking, not to bring in different things, but we were talking about Macmillan last time, there were a number of inferences that led to that inference being made, or a number of facts that led to an inference being made in terms of the intention there.
Yes.
Here, it's about, well, we made out one fact, and therefore the presumption prevails.
Yeah. It's interesting how they start that, because it's not a very lengthy judgment, as you've seen, but it's a nice little intro into the decision, and I do like that clarification that they make. All right, let's get into the timeline. So the facts. Mr. and Mrs. Bosanac were married in October 1998. In 2006, in April 2006, Bosanac, Mrs., I have to remember to say Mrs., offered to purchase the Dalkeith property. So this is the matrimonial property for $4.5 million, subject to obtaining approval for a loan of $3 million from Westpac. In May, the offer was accepted, and Mrs. Bosanac was required to pay a deposit of $250,000 within 30 days. In June, that $250,000 was paid or withdrawn from a pre-existing joint loan account in the name of both Mr. and Mrs. So joint funds used for the deposit. Note that. October, Mr. and Mrs. Bosanac applied, so both of them, applied for 2 new loans from Westpac in the amount of $3,500,000 and $1 million. And Westpac provided those loans, taking security over the Dalkeith property and other properties as well, including properties that were owned solely by Mr. Bosanac. So by October, we'd had a jointly funded deposit, and we've got borrowings from both of them for a purchase of a property that was just going into Mrs. name. So November, she pays the $4,252,948 at settlement, which is obviously the adjusted amount post the deposit, and it was transferred into her name as the sole registered proprietor. On that same day, Westpac sends its letter to Mr. Bosanac confirming a joint loan account in the amount of $3,500,000 had been opened, and the customer's contribution of $998,000 was applied towards the settlement, leaving a surplus of $243,650, which was paid. Those numbers don't make sense, actually. Paid into a joint transaction account of Mr. and Mrs. So you get the picture. There were joint borrowings. Mortgage register. I think
it's important as well. Sorry, I was going to say, so joint borrowings, but also joint funds that were used, and joint security given.
Yes, that's right. That's right. So one of those securities, of course, is the security over the Dalkeith property itself. They move in 2006. By this stage, they'd already been married for 8 years. But they then separate about 6 years later in 2012 or 2013. They do continue to live together until about mid-2015, but didn't divorce until then. It was in September 15 that Mr. Bosanac has his new residential address updated to the ATO. So there's definitely been sort of separation from that matrimonial property at that point in time. And then in April 2016, as we talked about earlier, the Commissioner of Taxation was pursuing Mr. Bosanac for some tax liabilities. $9 million is a lot. It was $9,344,000 and some change. So not an insignificant amount. The Commissioner obtained summary judgment, but the judgment, as I said earlier, was stayed until further order, and subsequently lifted, and the Commissioner of Taxation commenced these proceedings, and that was to facilitate recovery of part of the judgment.
Question without notice.
Sorry.
Do we know why it was stayed?
No, but and it's a lengthy period of time, 3 years. I don't know whether there was some, because it was summary judgment, I'd be surprised if there was sort of tax objection or gone through the objections through the ATO directly. I haven't been able to find any specific. There was no appeal to that earlier recovery proceeding, but maybe there was some lengthy negotiations or installment arrangements or what have you, and there was an agreed stay. That stay may have been by consent. We do see that happen. But in any event, as soon as the stay was lifted, the Commissioner commenced these proceedings seeking that declaration in respect of that Dalkeith property. So that proceeding was dismissed at first instance, as we said. And then the appeal was made to the full court of the Federal Court. A 3-judge bench was successful, which means that presumption of advancement that was upheld at first instance by the primary judge was overruled by the 3-judge bench of the full court, and that decision was delivered in August last year. So Mrs. Bosanac then, as I've mentioned, filed an application for special leave to the High Court, which was granted, and we're now mid-proceeding. So shall we have a look at some of the arguments at first instance? So the Commissioner we have seeking that declaration, arguing that Mrs. Bosanac was holding 50% of the property on trust for the husband. So straight down the middle, 50%, no. Sometimes we see in these resulting trust cases and these presumption of advancement cases, not just 50%, obviously, but the specific calculation of the monetary contributions made. It could be 20% or 70%.
Did we have any idea of, we were talking about there was a separation. I'm not sure whether there was a final divorce or a property settlement on foot as part of that separation. But I know that sometimes they're sort of things that are taken into account, particularly in a bankruptcy situation. You're looking at what the actual position is in terms of the matrimonial pool, the contributions, the non-financial contributions. I know that's not necessarily the tax officers or the Commissioner's priority to make out that case. But I would find it interesting, given that there was that family law element in terms of the separation and the divorce, whether or not, the situation in terms of children, in terms of those sorts of issues, would have altered that 50-50 position at all, and whether she might have made a claim separately in that regard.
Well, it does become problematic. I don't know. Firstly, if there were property orders made in any related family court proceedings. But I do know that it does create or add a layer of or an element of uncertainty or concern when acting for a trustee in bankruptcy, as well as, I suppose, the same would apply for the Commissioner. If the Commissioner had to take into account an order made by the family court, leaving that property solely to her, or even if it didn't expressly deal with the property, which then I suppose would infer some position on Mr. Bosanac that he didn't think he had any interest in that property, so could have been used as evidence in these proceedings. But dealings with other properties or other assets, and there's always evidence in those related proceedings that can be relied on to show not just intention after the fact, but that subsequent dealings with properties from which those inferences can be drawn. And I'm so pleased now you mentioned that clarification re-inferences, because it does become relevant in this case because of the subsequent conduct of Mr. Bosanac when dealing with the property as well. But yeah, I don't know the answer to that, Alice. I don't know if you asked that question knowing the answer already.
No, I didn't. I just think that it's interesting on these things to discuss relevant issues. You know, we discussed this last time as well. We talk about Cummins, we talk about Calvert Green, we talk about all these cases in very broad brush strokes as though, well, this must apply or this must apply. And I think it's really handy to just make mention of the nuances that can apply in certain matters that then make them not always, you know, that cookie cutter representation of what happens all the time. We can run that case because this is what happened in Macmillan, or this is what happened in Cummins. It's like, well, did it though? Is that what happened, or are there other nuances that we do need to look at? And I think the mention in this case of those family law principles are just something, a bit of a red flag, something that we would look at, when looking at whether or not we have a claim or what the extent of that claim would be. I also think it's really interesting, and you might come to this, so apologies if I'm cutting ahead, but that Mr. Bosanac, didn't actually give any evidence, as I understand it, in this matter. And so we can't draw inferences from what happened around the time and subsequent, which, again, as you said, may have come out in terms of some of the information provided should there have been family law matters going on at the same time.
And look, it's such a good point, and it is something that might not be readily apparent from judgment sometimes, but if there were family court orders which dealt with this property or even didn't deal with the property, you can infer from the omission of the property in a family court property settlement that there was never any claim by Mr. Bosanac to an interest in that property. So either way, it would really be relevant material, you would think. But no, I haven't seen any mention of that in any of either the first instance decision or obviously on the full court of the federal court, and certainly not in the submissions that have recently been filed. So I think the answer to that is I don't know. And let's come back to what we were just talking about, Macmillan and failure. I say failure, it's not necessarily a failure. I'm sure it was a very strategic move not to have either Mr. or Mrs. Bosanac give evidence. Because Mrs. Bosanac didn't either. Apparently she filed 2 affidavits in the course of the proceeding, but neither of them were relied upon at the hearing. So bear in mind what we said at the outset, which is that the onus is on the commissioner to lead evidence to rebut the presumption. So perhaps strategic decision not to have Mr. or Mrs. take the stand and give evidence about their intention, because
absolutely,
it's not necessarily the case that they wouldn't have given evidence that helped their case, but that decision may have been made that they didn't think the commissioner would meet the threshold, so to speak, and get to a point where that onus was successfully carried.
So I'm just referring to paragraph 18 here, which notes that the commissioner substantially relied on the unchallenged evidence of an officer in the ATO to establish the core facts on which he relied, including the facts relating to the purchase of the Dalkeith property. So it's really interesting that was unchallenged, firstly, and secondly was basically the foundation upon which this whole matter has been run, is that some guy from the tax office led some evidence as to what may or may not have happened.
And could not possibly have led evidence as to intention, because, hearsay and all the rest. So yeah, it's interesting. It's interesting that Mr. Bosanac didn't take the stand, and obviously, as you see, and I'm looking at paragraph 18 now, that leads to them stating that the outcome of the appeal turned on assessment of inferences that should be drawn from the facts as found by the primary judge. And yes, those facts came from an officer from the ATO. Interesting. Okay, so the arguments at first instance. So the Commissioner argued that the presumption of advancement ought not exist where the parties contributed equally to the purchase of a matrimonial home, which was used for a joint benefit. And you've mentioned Cummins. There's that very interesting case of Cummins back in 2006. I think the reliance on Cummins by the Commissioner was not, it wasn't particularly helpful at first instance, obviously, but they've carried that through, and we'll speak to that later on the appeal as well. They further argued that it was a natural development of the law of equity to meet societal standards, building on prior developments of the presumption, in support of the court rejecting its application to the present facts, including that it extended to apply to purchases in contemplation of marriage, determined not to apply to de facto couples, and extended to apply to gifts from a mother to her child. So lots was raised at first instance.
Can I ask another question?
Yeah.
And again, apologies if you're going to raise this a bit later, but so we talk about the matrimonial home, and we're talking about, this was 8 years, I think, into the marriage. So it wasn't in contemplation, but it was, we're married, we're going to move into this place, and we'll put it in Mrs. Bosanac's name. Would it have been different, do you think, if it was an investment property as opposed to the matrimonial home? Does it need to, for the presumption of advancement, does it need to be the matrimonial home, or
No.
is it any property at all?
Yeah, so I mean, the presumption of advancement arises from and should be focused on, in my view, the relationship, not the transaction or the gift itself.
Yeah.
And of course, the relationship is husband-wife or parent-child, and the transfer or the transaction, the gift, could be anything. Having said that, in this case, there is a lot said about the fact of it being a matrimonial home, which obviously then was going to have joint use and joint benefit, as being one of those key things supporting the inference that the intention was to retain that benefit legally. So, look, I don't think it should matter whether it was matrimonial or investment. Having said that, if it was an investment property, and it was solely in Mrs. Bosanac's name, and Mr. Bosanac then had, and it was even a step further removed, because obviously wasn't living in it, wasn't having any benefit or joy or use of it, I think the argument would have been different, because the fact that there's so much focus on it being a matrimonial property, mind you, there are many prior authorities dealing with matrimonial properties as well. That was one of the key factors, and I think it's one of the two primary bases on which the full courts found that the presumption was rebutted, because it was a matrimonial property that Mr. Bosanac did have that joint use and benefit of. And that's actually where we're just getting to, that those arguments of the Commissioner stated the fact of it being a matrimonial property where they resided for 7 years should rebut the application of the presumption. And the second aspect was that Mr. Bosanac's contribution to the purchase price took the form of borrowed funds, and those funds were borrowed on the condition that Mrs. Bosanac would register a mortgage in favour of Westpac over the matrimonial property to secure those funds. But they were both jointly and severally liable to pay the entirety of the funds advanced. So Mr. assumed substantial liability in respect of that transaction. There is evidence of shared bank accounts and sharing of other property assets, but in this particular case, the evidence shows that both Mr. and Mrs. Bosanac had separate assets, separate property holdings as well. So all that came into consideration by both the primary judge and the full court.
Sorry, Tim. I was just going to say, I think it is really important here too to note that he didn't have to go on the security from the facts that I've read as part of that decision. So, there are times when, one party needs to go on the, as a mortgagee or as a guarantee or as some part of borrower of the funds to basically firm up the position to get the finance for the property. But on all accounts here, he didn't have to. So that was a conscious decision that they made he made at that point to assume responsibility for some of the borrowings against, or half, the borrowings against the property, which was quite substantial in a situation where he didn't have to.
Yeah. So that's another one of the facts that's relied upon to support that inference, that intention to retain that interest was there, because otherwise why would he take on that substantial liability? But we really then are nitpicking around this gift, aren't we?
Yeah.
So when you think about what this legal principle is, it's really quite simple. And it's as my view is that the courts now probably are trying to move towards a more not just a clarification of the principle, but perhaps bringing it into the 21st century. So now is the time to do it. Now, I think this case is setting them up to do it, and they will. But it does seem to me that to move the focus away from the relationship and start talking about, was it a substantial gift, was there a substantial liability to attach to the gift? These are not focuses or elements that have existed prior to this decision. And there is a really long line of authority that has applied this presumption of advancement. So they're positioning themselves for a change, which, hey, is a good thing. I mean, it really is a very antiquated notion that we keep applying. And depending on, obviously, we do a lot of work with trustees, Alice, depending on whose side you're arguing for, it's a good or a bad thing.
Well, that's it, isn't it? But even things so far as, the de facto principle and how it doesn't extend there, which to me is, quite unusual given, basically everything else extends, these days, generally speaking, to the de facto relationship as well. So for mine, but for the fact that these guys are married, this wouldn't be an argument. And I think that's a really interesting and, again, quite antiquated way of looking at it. But as you said, look, the law's the law, and it's not up to just general, I don't know, it's not up to us to try and mold it into something that fits today's society without actually seeking that high court clarification or legislative change. And I think we're finding that in quite a number of matters at the moment, where it's just it doesn't sit right, but it's still the law. So we need to either have some change put in place, but it needs to come in place through the right channels.
Exactly, 100%. And that's I think what they're trying to do now. And the finding of Justice Makaracha, I don't know if that's how you pronounce her name, but I'll jump to that. And this is a quote: "The notion that a husband is presumed to give property to his wife, while the same may not be presumed of a wife to a husband, between same-sex spouses or between de facto partners, may grate with modern ideals and expectations of equality. But as things currently stand, the presumption of advancement remains part of Australian law, even for the matrimonial home. And it is not for a judge sitting at first instance to depart from such long-standing legal concepts." So in one way, she's sitting there going, file an appeal, but I have to do this. So what did the Commissioner of Taxation do? Filed an appeal. Okay, so let's go through this. The court ordered that the appeal should be allowed on the basis of a finding of fact that Mr. and Mrs. Bosanac purchased the property for the purpose of a matrimonial home, moved in shortly thereafter, suggesting, of course, mutual use and joint benefit. So the reasons for the judgment: the husband would be unlikely to accept such a substantial liability, jointly signing the loan documents. And as you've mentioned, Alice, we've seen that before. We've seen joint borrowings. We've seen, no, your husband needs to be on this as well. But that was a necessity. Whereas here it wasn't. They each were independently, I mean, I haven't read this, but looking at it, they were independently wealthy. She could have funded it herself, from what I understand. So for him to take on that liability without retaining some beneficial interest in the property. So here we have the court really looking quite closely at the nature of the transaction, which does take it a little bit further than, that simple statement of the principle. But they obviously deemed that substantial liability and the failure of the primary judge to take that into account as being inconsistent with an intention to forego that beneficial interest. Then they looked at the contributions to the purchase price. Both the deposit and the mortgage, as we know, were paid from joint accounts, which both husband and wife had contributed to. And the court considered that the presumption may be more likely to apply when a property is purchased outright with no encumbrance, which I suppose when you're thinking about a gift, it's not a gift that has to keep giving, fortnightly or monthly repayments for the next 25 years. So that's an interesting consideration as well. So they found that the primary judge had erred in failing to consider that significant liability. One of the things that we've talked about, I don't think it came up in the initial recitation of the facts, actually. Mr. Bosanac had subsequently used the property to secure further borrowings of $3.6 million to pursue share trading activities. And the full court found that this supported an inference that the property was available to the use of both parties. So we already know that because they were both living there. So it really just adds another layer to that use of the property. And Alice, you and I have touched on this in our recent discussion about this, and in particular, you referenced Macmillan, I think it was, about that subsequent events, and that's not really, it's not direct evidence of the couple's intention at the time they purchased the property, so it's not directly probative of that. But the court considers the use of the property by Mr. to secure those borrowings, and held that supported that inference drawn from the circumstances that the purchase as well at the time of the purchase, that the Bosanacs intended that the property would be available to both of them.
And I find that really interesting from the perspective of, and they go to, some pains to tell about, there are properties that are held by them each separately and other assets and other, finances, etc. And we're not to know because we don't have, their evidence on this regard. But if he didn't think that half of that house was his, yet he had other properties, why didn't he secure the borrowings against those? Why was it this property? And maybe it was against more than that. We don't know. And that's okay. But these are just questions, I think, that come up that I think actually make this a little less clear than it can potentially sort of be, well, he borrowed against the house and so it must be.
Yeah. And I mean, and you have to stop and wonder what the evidence around that would have been. Because, you could probably think of half a dozen other reasons why. Maybe it was just easier because of the nature of the facilities and
they did.
Easier just to borrow down this.
Rocket redraw facilities and rocket repay home loans. So it could very well have just been convenience.
Absolutely. It's an interesting point, and had perhaps either Mr. or Mrs. taken the stand, maybe we would have the answer to that. But look, the upshot, let's jump forward, is that Mrs. Bosanac is now found by the full court of the federal court to hold 50% of her interest in that property on trust for her ex-husband. And therefore available to the commissioner to enforce that judgment, obviously.
Mhm.
I wonder how much the property is worth now.
Yes.
And how much equity is actually there. What does 50% actually look like? I wonder if it's the full 9 million.
Well, but especially after that investment loan, because that actually was a significant, it was 3.6 million that he borrowed back from that loan.
Activities.
Yeah, exactly. So that's, I mean, when you look at how much they borrowed initially to purchase it, and obviously property has, increased and done amazing things over this recent past period. But 3.6 million, that's a decent chunk to eat in to the equity of the property that may have otherwise, been there at this point in time as well.
Yeah.
And I mean, we haven't even started talking, and I mean, not for today, and I'm sorry because I haven't raised this before with you, so I don't have a conniption, but we haven't even started talking about sort of doctrine of exoneration issues here that we would normally look at in terms of, okay, well, if it is half, and then he took out 3.6 mil for his share, and he's used that part of the equity, in reality, if we want to add more and more, presumptions and doctrines and the rest of it into the soup mix, what happens there? I mean, she may have...
If he's drawn down 3.6 million of the equity for his share trading activities, of which she has no interest in, then yes, let's apply the doctrine of exoneration. We've got the equitable accounting principles, all those sorts of things that, if it was you, Alice, chasing my client, I'd be throwing all these things at you.
I have no doubt.
That's why those calculations are very rarely 50% right down the middle.
Correct.
It's like you're applying these equitable principles and this doctrine here. It's often a little bit more of a precise science around what that interest, assuming that presumption is rebutted, what that interest would actually look like. All right, so I'm going to finish off with a quick discussion around what I know to be the appellant's written or the appellant's position now, because of course the Mrs. Bosanac made an application for special leave to appeal, and that application was successful. So we do now have the case before the High Court. Now, let me just go to my timeline. There was I think the special leave application was in April, 12th of April. It was successful, and the notice of appeal was filed on the 26th of April. Now, the appellant has on the 31st of May filed her written submissions, I should say, and a chronology, and the respondent's written submissions are due next Tuesday. Very timely. We're right in the middle of it. So I've read through the appellant's submissions, and they raise a number of interesting and really concise arguments in my view. And maybe my position will change again after I read the Commissioner's response. But they tackle the issue raised by the notice of appeal. Raised in the notice of appeal of whether the use of borrowed funds to make an advancement is enough to rebut the presumption of advancement, and whether the decision of the full court introduction of those further presumptions or default inferences, I should say, and you've clarified the inferences around borrowing for the matrimonial home as opposed to some other property or gift, really constitutes a quasi-legislative frittering with a rule of law. That's a direct quote. A frittering with a rule of law which has been relied on by people to manage their affairs for generations. And this is exactly what we were just talking about. So some interesting aspects that they raise in the submissions. There's no suggestion that the property was registered in Mrs. Bosanac's name with a view to avoiding creditors. So that was clarified, but really not in question, I don't think. They had, during the whole course of the marriage, kept their substantial assets in separate names, not sharing all the matrimonial assets jointly, and not pooling their shareholders, which I suppose you can look at one of two ways. Is that evidence in support of an argument that she was to retain this benefit solely, or is that they've done something different to what they usually do? Why did they do it here? Maybe there was an intention for him to have some interest in it. But they talked to that he had a substantial share portfolio in his own name, and she and he both owned other properties. So they recite those facts in support of a conclusion that there was that considerable evidence of separate ownership of property and separately owned properties as security for joint loans. Again, if that was the case, why did they do something different for the matrimonial property? And does that then just feed into the Commissioner's argument, well, we should treat the matrimonial property differently? Yeah, so it's interesting.
An interesting one.
Yeah. Okay, let me just have a look here. So the full court had found that the primary judge made that error in excluding the consideration of the fact of the substantial liability. But the applicant's submissions quibble with this finding, saying that it was integral to the presumption of advancement that something of substantial value was being transferred without a corresponding beneficial interest. That's the very nature and foundation of the principle. And I mean, you have to agree with that, surely.
Yeah.
So it's a good submission. They also point out that to rebut the presumption, the court must identify facts that support the intention to declare a trust. That is a definite intention to retain title. And they submit that those facts can't be the same facts relied upon to underpin the presumption in the first place. So go back to the substantial nature of the transferred asset. The court has said, well, it's so substantial. It's too substantial. He's taken this liability. So that must undermine it. But the principle itself is that something of a significant nature is being gifted. So it's...
I do think there's a difference, though. I think that there's a difference. If I own a house, it wouldn't apply if I give it to you because we don't have the correct relationship. But, for example, if that relationship did exist and I owned a house and I gave it to you and then I walk away...
I can be your child.
Do you know? Yeah, okay, that's fine. Sure. Anyway, I would give that to you. I would walk away and then I'm done.
Yeah.
But I think that is quite different to me than having an ongoing liability for something that you get the benefit
I don't. Of course. Again, we look to the relationship. The relationship is husband and wife or parent and child. So if I'm living with you at the wee age of 30, and you purchase a house in my name, but we keep residing together and you keep meeting the mortgage repayments, is that liability that you have taken on, notwithstanding having put the property in my name, enough to undermine that presumption of advancement that you as my mother have done for me?
I think that it's different. And the problem is we're talking about current societal trends, okay? And I understand that. And I'm assuming, and, correct me if I'm wrong, but I'm assuming that presumption of advancement, something that came in when we're talking about contemplation of marriage, and it's something that has been around for hundreds of years, potentially, at a time where, for example, the wife probably couldn't work, for a time when there has to be some sort of, transactional value situation given in that sort of matrimonial situation. When that is the case, we're not talking about mortgages for $4.5 million over a property at the time when we see the presumption of advancement coming into being. So I think that there are issues that require clarification that potentially do raise a lot of question marks, because I'm not sure that this situation with the mortgage and with the ongoing security and the over 25 years was necessarily what was intended when the powers that be, in times gone past, actually brought into law this presumption of advancement. Again, not up to us to, try and mould that into something that we think it should be. That's what the High Court's there for, or the legislators. But I do think that that's where a lot of these questions get raised, because it's a totally separate situation to, here you go, here is a block of land, here is a property, etc. Then I will now continue to pay for it.
Yeah. I think it is. I think the principle is going to. I think it still has application to the parent-child relationship, and I think the risk. We either have to get rid of it completely, because if you're going to some of the arguments that have been raised throughout the course of these proceedings, both at first instance and on appeal. When you're looking within the context of a man and a woman and a husband-wife, yes, you can start picking it apart and saying, okay, well, this should apply and this shouldn't apply. But when you're looking at a parent and a child, it's a completely different context. And the same inferences will not be drawn, I don't think, adversely or to undermine the principle of the presumption of advancement in that parent-child relationship about the ongoing mortgage payments and things. I think it would be treated completely differently. So if the principle is not going to sit neatly over those relationships because there has been over time an evolution of the tests surrounding the application of that principle, then we either need to get rid of it completely or we need to legislate it more specifically. And I think that's what both parties are submitting here anyway. But until that happens, Mrs. Bosanac's argument is that there should be no departure from it. And it being that antiquated principle that's been around for hundreds of years. So, look, that's pretty much where I got to with this. I think it just raises so many arguments and interesting discussions. Even just on that basic level of really a husband and wife and parent and child and same-sex relationships, all those sorts of things.
Facto relationships. No, I totally agree. And I think that, we're finding in some of these matters, it's actually a really good spotlight on the fact that we've got some great, insolvency law to talk about. But in comparison to how many of these similar matters that we deal with, we actually don't have that much insolvency law that pinpoints certain issues. And the reason is because things can be so vague, and the amount of money that it does cost to run things to trial, and you do try and fit things into certain cookie cutter, arguments on both sides, don't you, to see what comes out at the end. And I think the fact that we don't have evidence that was led by Mr. or Mrs. Bosanac here, I think in the matter we referred to last, the Macmillan matter, we only had the Mr. gave the evidence and Mrs. didn't. And, we can draw whatever we want from that. But I thought just finally from me, this paragraph 26 in the appeal decision I really quite liked, where it talks about the concerns that the primary judge's reference had to the fact that Mr. Bosanac described himself as a self-styled venture capitalist, and that His Honour referred to him as a sophisticated businessman. His Honour concluded from these matters that Mr. Bosanac must be taken to have appreciated that the name in which real property is held is of significant consequence in almost all situations. As we see it, however, there are two difficulties with this conclusion. Both arise from the fact that Mr. Bosanac did not himself give evidence. First, the primary judge's appraisal did not rest on an assessment of Mr. Bosanac's own evidence, since there was none. And secondly, there was no direct evidence of what Mr. Bosanac perceived to be the significance of the Dalkeith property being put into Ms. Bosanac's name. So plainly enough, the inference drawn by the primary judge was just not the only one available. So we'd not therefore place as much, if any, weight on the primary judge's characterisation of Mr. Bosanac's business acumen. And I think that's really relevant because it's, again, we're assuming, we're inferring, but we don't know.
No, he didn't give any evidence of that, did he?
No. So I think that's great. All right. So we wait and see.
We wait and see.
Okay.
So if you want to read the Commissioner's submissions, they should be online within, certainly by the end of next week, I would have thought. And then let me just see if they've got a hearing listed. No, not yet.
Well, once we've had a look at those, Stace, maybe we can just pop in for a quick 5-minute chat, and then we can share that on our Insolvency Bites, the YouTube channel, but also the LinkedIn page for that, just to have a quick chat about what we found and whether or not that changes.
It's going to be really interesting where to from here. I mean, this principle has survived for a really long time, and certainly a lot longer than a lot of successful women would think was appropriate. So it'll be interesting to see if everything comes to a head.
Excellent. Thank you so much for your summary of that matter. I thought it was a really interesting one. I'm looking forward to seeing what we decide to cover next.
Yeah, fantastic. See you next time.
Thank you, everybody, and we'll talk to you again soon. Have a great afternoon.